everyone. Welcome to the May meeting. I'm first going to introduce Julia. She has a few words, and then we will introduce the next person. So go ahead, Julia.
Good morning, everybody. Good to see you all. Thank you for coming on this morning. We're coming to the end of our year. You know, our fiscal years for the Safety Council is July to July. And I have fabulous news. We can go back in person. And they are bringing back the rebate. Everyone can cheer and holler and yell because that's been such a good thing for everyone. So our new meeting first meeting for the new year will be in July. I am working on a location and I'm working on some other new additions. So keep posted. We'll let you know for sure, but we are going to continue into next year, and there will be rebates available, and they've lightened up on a lot of the requirements for busy work for you, which is also great news. And we also have a commitment. We're going to have the big outdoor signage on I-75 or 725. I don't know the location yet. Promoting our Safety Council, because as you know, there's only 2 for the Bureau in Montgomery County, and we're one of the 2. So it's a very special honor for us as well. So got a great speaker today. We're happy to be continuing Safety Council and enjoy this gorgeous weather. My heavens, finally, I think we're through the winter. Take care, everybody. Bye-bye.
Hi, I would like to introduce Suzanne Shamus from the BWC. Welcome, Suzanne.
Good morning. A couple talking points this morning. Private employers, your ISSP, Industry Specific Safety Program Requirements, and PAR, Policy Activity Rebate Program. That you must complete your requirements for that program by June 30th. So you have about 45 days to get any required classes in with both the Industry Specific Safety Program and the Policy Activity Rebate, or ISSP and PAR programs. You can now do those classes online. Although in support of that, we also have a lot of virtual classes coming up to help you get those requirements completed. May 23rd through the 25th, we have a 3 half-day electrical safety maintenance, NFPA 70B, practices for electrical equipment maintenance. That is a very good class for anyone in maintenance who does any electrical work to attend. We have a few seats left in that class. May the 24th, we have a 2 half-day controlling workers' compensation costs. This is a good class to take even if you've never had a claim or you're a small company, because that way you know what to do in the event that you do have a claim. May 31st, we have a hazardous material and waste shipping and reporting requirements. So if you ship anything that might be considered a hazardous chemical, that's a great class for you to attend. In 3 hours, you can get the Cliff Notes on what you need to do. On June the 1st, we have our Violence in the Workplace class. That is a very widely attended class. We currently have 50 students enrolled, and we are 50 or 80 students, but we're bumping that enrollment up to 100 to allow for additional attendees. June 2nd, we have a thermal stress class. OSHA has recently announced a national emphasis program for heat stress. So this is a great time to take that class to make sure that you and your company are in compliance and you have the proper programs in place and the proper protocols for work rest regime coming to the summer. Even especially this week, if you have workers that are not acclimatized to the weather, make sure you're giving them extra breaks, because you may wind up with somebody with heat stress or heat exhaustion, especially if they have accompanying medical hazards, like they take diuretics for heart medication or anticoagulants. Those can be very hard for them to adjust. We have a lot more classes. June 9th, we have accident analysis. June 15th is a crisis de-escalation tactics and safe practice workshop. That is a great class for anybody who may have a violence in the workplace situation or works with people. That is one of the classes included in our developmental disabilities grant. This class is open to everyone though. June 16th, we have electrical hazards recognition and abatement. June 21st, we have a safety series module 5, electrical safety and lockout tagout basics. June 27th, scaffolding safety workshop. If you erect scaffolds or you work on ladders, you may continue, or you may consider attending that class. On a note for employers, I run into a lot of employers that are unaware that they're required to report the hospitalization of a single employee if it occurs within 24 hours of the accident, the loss of an eye, or the amputation, and they have 24 hours to report that to OSHA. You can report that online or by calling your local area office, or there's also a national 1-800 number. And if you have a fatality in the workplace, you only have 8 hours to report it from the time the CEO or top ranking official becomes aware of it. Also, machine guarding. If you can reach over, under, around, or through, it is not guarded. So if there's a place where you can reach into that point of operation and the employees are not supposed to, it still, according to OSHA, is not properly guarded. So make sure you're looking into those hazards. And now I am going to introduce our speaker for the day. I am introducing Michelle Bach, attorney at law for Coolidge Wall. She is going to speak on how to play good defense, a playbook for employees. Michelle concentrates her practice in the area of workers' compensation defense. She has been recognized as a certified certified specialist in workers' compensation law by the Ohio State Board Association. Michelle represents state-funded and self-insured businesses and public entities. She routinely attends hearings before the Industrial Commission of Ohio. She is also a skilled and experienced litigator. She has handled many bench and jury trials in various courts of common pleas throughout Ohio. She also handles actions pending in the Court of Appeals and before the Supreme Court of Ohio. Michelle routinely advises clients regarding how to control workers' compensation costs. Michelle has been selected by her peers for inclusion in the best lawyers in America in the practice area of workers' compensation law from 2012 to 2017, and has received Ohio Super Lawyers recognition as well.
Good morning. Thank you very much. I'm going to make a mental note to make my bio a little shorter the next time, but thank you for that introduction. As she mentioned, I do represent employers in the area of workers' compensation law, and today we're just going to talk about some strategies for defending your workers' compensation claims. So just a general playbook for you to use with respect to the workers' compensation claims that you might need to be handling for your businesses. So let's just get started here. My first piece of advice is to pick the best coach for your defense, for your team in general that will be handling your workers' compensation claims. You certainly want to pick someone like the guy on the slide, right? Vince Lombardi, someone who has a trophy named after him, someone exceptionally skilled in the area. And that's what you want to do with respect to workers' compensation as well. Typically, an employer has two options with respect to representation in the workers' compensation arena. You can be represented by an attorney in private practice or by a third-party administrator. It is important for you to know that there are significant differences with respect to these various types of representation when it comes to attending hearings before the Industrial Commission, and we will be talking about that in detail in a minute. As lawyers, we are permitted before the Industrial Commission to do certain things that a TPA representative cannot. For example, one of those big things is that we can, of course, cite the law. We are lawyers, we have specialized training, we are certified to practice, and therefore we are familiar with the law. We can cite cases in support of our arguments, and it's a big part of what we do. I'll be talking about some of those cases later in the presentation. The other primary thing that an attorney can do for you in the hearing room is to argue. And all you need to do is to talk to my husband for a short period of time, and he can let you know how much I like to argue about things. And that is what we are experts in: the art of persuasion, the art of argument, the art of putting all of the puzzle pieces together. I think a good analogy is a TPA representative, and we'll talk about this in a second, can show those puzzle pieces to the hearing officer, but cannot actually link them or put them together. A huge part of what we do is link all of those puzzle pieces together to show the hearing officer the result that we are trying to obtain. And again, there will be more about that to come. The other thing that an attorney can do for you in the hearing room that a TPA representative cannot do is to cross-examine. For example, if the issue at the hearing is allowance, whether a claim should be allowed, whether an injury happened, certainly you would want to be able to ask the claimant basic questions about how, when, where, why this injury happened, when they reported it, to whom they reported it, when and how they obtained medical treatment. There would certainly be questions perhaps about their pre-existing medical history, on and on. I'm sure I probably mentioned this to many of you in the past. I am extremely inquisitive by nature. You know how most people talk about the terrible twos and how a toddler will constantly ask why, why? I feel like sometimes I've just never really grown out of that. I love asking questions. I love getting information. It's a huge part of my job and something that I really enjoy, and something that is really at the core of what we do when we are trying to analyze and present our cases. By contrast, again, the TPA representative can only show the puzzle piece. They can essentially only read the evidence that is already on file. For example, Dr. Smith says so-and-so, or this report says, and then they can essentially read it verbatim. Well, obviously the hearing officer can read those reports for his or herself. What they're looking for is how all of those puzzle pieces fit together to indicate whether a claim should be allowed or denied, whether medical treatment should be approved or not, and so forth. So I would urge you to pick the coach of your team very carefully before you even get started with respect to the defense of your workers' compensation claims. The second tip is you definitely need to know your playing field. In the field of workers' compensation, there are essentially two forums, and we will talk about both of them today. The first one is one that you may know well, and my picture is so outdated. I need to get a new one where it doesn't have, the temporary signage there. But this is a picture of the Industrial Commission out in Fairborn, which is where I attend hearings most frequently because, of course, it's closest to my office, which is in downtown Dayton, and where most of my clients are located. But as I'm sure many of you know, there are Industrial Commission offices throughout the state of Ohio, and hearings are always being held at those various offices. So here is a picture of one of the hearing rooms at the Fairborn Industrial Commission. As you can clearly see from the photo, it's a conference room setting. So the hearing officer, who is a lawyer, will be sitting at the head of the table there, and then the parties will be on either side. The claimant and his or her representative, if they have one on one side, and the employer and their representative on the other side. So I think this picture does a good job of demonstrating that it's a semi-formal proceeding. The rules of evidence do not apply, and again, it's more of a conference room setting. But what's very, very important for you to know and to implement in your own daily work is before you walk in that hearing room and before you're going to tackle an argument or to present a case regarding any issue that might come up, you need to be ready, right? Ready to play some defense. So when you walk in there, you want to feel and look like this guy, ready to play some defense of your claims in the hearing room. So how are you going to do that? I suggest that you use what I would call a zone defense. And in the field of workers' compensation, there are essentially three zones. You have your factual evidence, your medical evidence, and your legal defenses to a claim. So I always like to refer to this as a bit of a three-legged stool, and most of the time you have to have those three legs, those three zones covered in order for a claim to either be allowed or denied. Sometimes you may only have one or two of these defenses, but these are essentially the areas that you need to be looking at when you are evaluating your claims. So with respect to the fact investigation, what exactly does that mean? I suggest that this is akin to studying your game film. You really need to be looking at your case, learning about your case, and digging into the facts of your case. So how can you do that? First of all, I do often recommend that you deny certification of a workers' compensation claim. Many of my clients give me a lot of pushback about this. They want to accept what their employee says, they just want to allow the claim and move on with it. They really oftentimes do not want to do any type of fact investigation. By denying the certification, that does not mean that the claim will never be allowed. It just means that you're giving yourself additional time to actually perform the investigation. So how are you going to do that? One important tool is to have a very solid incident report form. If you do not have one, just shoot me an email. I would be happy to send you a sample one that I routinely pass out to clients. It is very important that your incident report form be sufficiently detailed and have enough information on the form to help you down the road. Some of my clients, when I first start working with them, do not even have an incident report form. You absolutely should have one, and you should actually be using it and be filling it out completely and promptly and accurately every single time. I can tell you that there have been innumerable times that I have relied upon an incident report form to argue against the allowance of a claim. Here is one quick, simple example. I had a case recently where the injured worker was a home health care provider. She alleged that she had to pull a patient up in her bed in order to reposition her, which sounds perfectly plausible, right? I'm sure that's something that they have to do all the time. She was alleging a knee injury as a result of doing this. Now, normally you would think if you're pulling someone up from behind them, you might have a back injury, but it doesn't really feel like a mechanism of injury for a knee. She was alleging a twisting injury of her knee. At the hearings that I attended, she literally, right in front of me, in response to my cross-examination, changed her story about how this happened. When I first asked her, she said she was behind the patient and pulling her up from behind and underneath her arms. Her attorney essentially coached her into saying, no, she was at the side of the patient, did a twisting motion to pull her up from the side. Well, luckily, the incident report form, which was completed on the day that this allegedly happened, in the claimant's own handwriting, specifically said she was behind her and pulling her up from underneath her arms. So again, that's a small but persuasive example. That claim was ultimately denied, and I think it was in part not only to the change in the mechanism of injury, because it also showed a significant credibility issue on the part of the injured worker. So I'm a big fan of a good incident report form. Similarly, witness statements can be absolutely invaluable. I was successful in defending a temporary total issue recently because I had a very good statement from the supervisor indicating essentially that he asked, the claimant asked if he could be moved to a different machine because he didn't like the machine he was being assigned to and he thought the work was too difficult. The supervisor told him he had to stick with it until he learned that machine first, and the guy basically quit on the spot. The supervisor was able to attest to that. Otherwise, I would have no evidence to indicate essentially that he had voluntarily quit and abandoned his position of employment. So again, witness statements can be very crucial as well. An employee handbook can be quite helpful. People often do not want to spend the time or the money to keep them updated, but I do frequently use them as part of my defense, especially if you have a policy regarding the immediate reporting of injuries, There are many, many other policies in your handbook that can be invaluable. I would encourage you to make certain that your handbook is up to date and that you're distributing it and that you are using it. Surveillance can be another helpful part of your fact investigation, or with respect to damage control of a claim down the road. Some of you may have heard me talk about one of my favorite war stories about a woman that was claiming she had chronic regional pain syndrome, could not use her arm at all in any way, shape, or form. Luckily, we were able to get surveillance indicating that she was out mowing her grass, hoisting up heavy poles for a volleyball net, wrapping a volleyball net around these heavy poles, doing all sorts of things that were quite helpful, and ultimately led to us being successful in overturning a claim that had more than 6 figures of exposure for this self-insured employer. I also had an interesting case here recently, a court case where the claimant kept canceling her deposition. Apparently she didn't want to be subjected to my cross-examination, right? Even though it's normally a very friendly conversation at that point. We finally sent out the surveillance team on the day she was supposed to be deposed, but she canceled it. She said she was out of state visiting her brother who was hospitalized due to an auto accident, and we found her here in the local area shopping at Walmart. So it's just, sometimes you get something that could be valuable, sometimes you don't. But I mean, clearly that woman is going to have a massive credibility issue down the road. Our second zone is scouting the medical history. Again, relying upon your medical defenses is also critically important. We always recommend sending our medical release so we can obtain pre- and post-injury medical records. Keep in mind that the BWC medical release form only entitles you to obtain records from the date of injury forward. Well, what if this person had a back injury the day before, or has been seeing a chiropractor for 2 years before this incident? You certainly want to get those records as well. The release that I send enables us to obtain pre-injury records. If the claimant balks at signing it, you can resort to the BWC medical release form, but normally claimants and claimant attorneys do permit the signature on a release that enables us to get those prior records, which again, I could tell you dozens of stories about how valuable that information can be. With respect to your medical defense, you want to go man to man. And by that, what I'm talking about is to make certain that your medical expert is going to match the qualifications of the claimant's expert as much as possible. One of your most important defense strategies is to obtain a defense IME. By statute, an employer is entitled to obtain an IME by a doctor they choose relative to any issue that comes up in a workers' compensation claim. So if the issue is allowance, additional allowance, medical treatment, permanent partial, PTD, all of those issues, you are absolutely entitled to a medical exam, and you should be getting those examinations on a very regular basis. Well, the tricky part, though, of course, is you have to pick a doctor to perform that exam on your behalf. Oftentimes, the TPAs will use a service where they just call the service, they pay them an intermediary fee, and it's kind of a, well, I don't know if I can use a Rolodex analogy anymore since nobody uses those, but it's kind of like flipping through a Rolodex to just find a doctor who will perform the exam. I only pick the doctors that I know and trust, that I've met before, that I've deposed before, that I've worked with for a long time. I don't just randomly pick a doctor from a list or let somebody else pick the doctor for me. So making sure that you select the right doctor with the right qualifications is critically important. All right, so what about our third prong, or our third leg of our stool, the third part of our zone defense, are legal defenses. And sometimes you just absolutely have to blitz with those legal defenses the very best that you can. And there are many, many of them at your disposal. Unfortunately, I was told my presentation is only supposed to be about 30 minutes, so there's no way we can go into the complexities of these as much as I would truly love to and as interesting as they are. But just to give you a list to have these running through your mind, this arising out of and in the course of employment is at the core of workers' compensation law. Obviously, an injury has to arise out of and also in the course of employment in order to be compensable. Those are two different prongs that are both essential and must be proven by the claimant. And there are many cases to assist you in the defense of this, and many arguments that often can be made along these lines. Some examples include the coming and going rule, which can be very complicated. I represent a number of home healthcare agencies, and of course their employees travel, so they might go from their home to their office, to a patient, to lunch, to another patient, to a work meeting, maybe drop their kid off at school or do something of a personal nature. So there's obviously a body of law that covers or tries to address those fact patterns, which can be very tricky. So you really need to evaluate carefully whether you have any legal defenses to a coming and going case. Another one is horseplay. You may have heard me talk about this story before many years ago when a large industrial client of mine would always have an annual Christmas party with an open bar. My number one piece of advice today is to never, ever have any type of work-related function with an open bar. An individual got a little too intoxicated, there was some aggressive dancing, there were some backflips on the dance floor. You can imagine how things just deteriorated from there. This individual claimed a back injury literally from doing a backflip on the dance floor. But we were able to argue that that was horseplay and he was not actually in the course and scope of his employment. Intoxication is coming up more and more frequently these days. There are very complicated rules regarding when an intoxication defense can be used and if or when it can be used successfully. That is absolutely something that requires a lawyer's close eye to review. I had a very serious case a couple of years ago. A gentleman operating a massive industrial saw. This company would build pallets for Caterpillar for them to put their equipment on. So a huge, high-tech, computerized saw was being operated by this injured worker. And to make a long, horrible story short, he basically stuck his hand into it to retrieve a piece of debris, and literally this saw blade slides down and back and down and back, and literally he almost had his whole entire hand amputated because he stuck his hand in there. We were successful in asserting the intoxication defense administratively. That case has been appealed to court, and we'll see how it all shakes out. I've had a rash of idiopathic injuries lately, also very serious, very sobering injuries. I had a gentleman, to make a long story short, who basically worked as a welder in an industrial facility. He was found by a coworker with his boot off, his welding helmet off. You know, again, in an industrial environment where you would not be taking your boots off or your welding helmet off. Appeared disoriented, not completely coherent, and they have no idea. No one is going to solve this mystery about what happened to this gentleman. Did he have a stroke? Did he pass out and fall? A seizure? Innumerable things could have happened. He was also recovering from COVID and had been ill just prior to this. Later, they found a massive softball-sized knot on the back of his head. So obviously the implication is he fell and hit his head, but as to when, where, or why, we have no idea. He was hospitalized for more than 6 months, is still trying to recover his cognitive function, had to relearn how to walk, relearn how to speak. Very, very significant claim, but so far the idiopathic defense has been successful there. I had another idiopathic claim here very recently. Strange fact pattern where a guy was replacing what are called like some UV cells in a 7-foot trench. When my client sent me photos of this setup about how they were doing it, I mean, it literally, I almost got chills about how poorly the whole thing was executed. They had removed all of the protective metal grating from the trench in order to replace something down inside and put a little thin strip of plywood along the top of it. And this gentleman was standing on that little bitty strip of plywood and basically passed out for some reason and fell. Someone apparently is asking me to define idiopathic, and the best definition would be unexplained. Also, it can be defined as something personal to you, so something like a seizure, heart attack, that type of thing. So this poor gentleman is on this little plywood catwalk essentially over top of this trench. He passes out and falls into it, which is full of like 10 inches of black mucky water, breaks his neck in 3 places from the impact, and basically is knocked out, unconscious, and they're, potentially suffocating in this small bit of water there. We are doing our fact investigation. Interesting story because it appears the claimant, who is a male, only weighs 90 pounds. So there's some specter of an eating disorder, all sorts of issues there. So those cases, again, can certainly have legal defenses that should be explored and presented as best as possible. There's a whole bunch of them. We're not going to have time to go through them, but we always look for pre-existing conditions. Natural deterioration is our go-to. We're always arguing that arthritis or some sort of degenerative condition is at play rather than something being work-related. We often evaluate the substantial aggravation standard. Oftentimes people do not realize that you must have objective clinical or diagnostic findings in order for a substantial aggravation case to be proven. And we, again, emphasize that all the time at hearing. Psychological conditions can be tricky. Village injuries are something that happen gradually over a relatively short period of time, and there's a whole body of law about those as well. And, okay, I needed to click again. The occupational disease standard can also be tricky and is defined by the law. Sometimes there can be a statute of limitations violation that can be argued. And voluntary abandonment is a very, very big issue. Again, we don't have time to get into all of that, but you should definitely know that all of the case law regarding voluntary abandonment has actually recently been replaced by a statutory definition that, in my practical experience, has proven to be of no value whatsoever. So I'm not sure what the legislature was thinking, but basically the statute says if the abandonment is due to the injury, then the claim and the benefits can still be compensable, but if it's not, it's not. Well, what about all of the fact patterns that I deal with where sometimes it's partially due to the injury and partially due to personal reasons, like someone who moves to a different state or someone who says, well, I quit because my knee was bothering me, but also because I want to watch my grandchildren part-time. So that's a very, very tricky area, something that needs to be carefully reviewed and analyzed if you ever have any type of voluntary abandonment case. All right, so we've gone through all the zones, the factual defense, the medical defense, the legal defenses. So you've evaluated all 3 of those with respect to your claim. And so now what? Well, you have to have a game plan, right? Because you're going to go to a hearing before the Industrial Commission. You're going to end up in that conference room that I showed you at the beginning. And here are some quick strategies. Sometimes you might want to call a court reporter. This does not occur frequently in my practice. I did do it recently in that case I just told you about with the welder who fell and was completely unexplained. The idiopathic law is very quirky. In short, and this is really simplifying it, if you fall and hit the concrete, it's not compensable. You fall and hit your welding machine on the way down, it is compensable. I was worried in that case, and I didn't know how with it this guy was going to be, that he might say, you know, I hit my head on this, or I know I hit my lunchbox or my welding machine or something. I wanted to have all of that recorded for the future, so that's a good strategy. You can call your witnesses live, which can very often be effective and something you definitely want to consider. If you feel the issue is complicated, I always recommend requesting additional time. The hearing officers love that. It's less work for them, less stress for them. They'd rather you take 30 minutes, but you asked for 60 minutes rather than the opposite to happen. You can submit the statements that we talked about, and of course you're going to rely on all of the evidence that you've put together. So let's say you do all of this, and then you come back to me and say, Michelle, I checked into my facts, I got those statements, I got my incident report, I got my defense IME, I even had some case law, some legal defenses, and my claim's been allowed. I was not successful. Then, of course, you have to switch over to damage control, and there are many strategies that can be utilized in this regard. And again, unfortunately, we don't really have time to review them in detail, but one is salary continuation. I would caution you, though, I feel like the TPAs often recommend salary continuation across the board, absolutely no matter what. Those benefits can be very expensive, especially depending upon how much your injured worker is going to be paid. I had a situation recently, I won't tell you the name of the client, but it's a ballet dancing company. So their work is seasonal in nature. This individual was injured basically the week before the production ended, and you know, it's a tricky question as to whether to pay salary continuation or not. There were some other concerns that this individual really just wanted to return to college rather than returning to the workforce. And the client was concerned they would, you know, keep paying her, but she wouldn't really return to work. So we talked through all of that and decided that it would not be best in that situation. Salary continuation can be great if it's a good employee who will be off for a short period, a short and finite period of time, and promptly returns to work. But if they're not going to do that, which of course your crystal ball is not always working, you don't always know if they will or if they won't, but I would urge you to look at that critically and not just automatically pay. Transitional work programs can be very helpful. You can make a light duty job offer. As I've told you folks in the past, please make absolutely certain that your job offers are in writing. They have to be in writing in order to be a defense to the payment of TT. If you have questions about how to do that or need a sample letter, please just let me know. I'd be happy to help you with that so it is done properly. You can send them to rehab, which is paid for by the state and not charged to the employer. You can get a maximum medical improvement exam. That's the type of exam that can be used to cut off their temporary total at the appropriate time. You can contest treatment, take that through the ADR process, and you can apply for handicap reimbursement, which is a credit to the employer if they have a pre-existing handicap like arthritis. So that's obviously a lot of information in a short span, but I just want to make sure that you know that there are many, many strategies that can be used to control the cost of a claim after it has been allowed. All right, so my last bit of advice is sometimes you just have to throw that challenge flag. Sometimes you just feel like it's the best thing to do. And what I'm talking about here is after the administrative process before the Industrial Commission concludes, you do have additional recourse. I can't tell you how many of my clients were completely and totally unaware that they could challenge an allowance decision by the Industrial Commission to the Court of Common Pleas. I think a lot of people unknowingly believe that if you have your 2 hearings before the Industrial Commission and you lose, that it's game over. That is not true. The law provides that either party can appeal a decision regarding allowance, basically other than extent of disability, to the Court of Common Pleas. So let's say, for example, your claim is allowed for a rotator cuff tear or for major depression or whatever it might be. You can appeal that condition to the Court of Common Pleas. Here is a photo of one of the courtrooms at the Montgomery County Court of Common Pleas, just down the street from my office in downtown Dayton. I spend about half of my time working on administrative cases and the other half working on workers' compensation litigation, again pending in this Court of Common Pleas or throughout the state of Ohio, basically. You can tell from the photo that it's a completely different playing field, right? This is not a conference room setting where there are a few people around a couple of tables. You have a chair at the end there for the judge. You have a witness stand. You have 2 counsel tables, obviously one for the claimant, one for the employer. But most significantly, all of those chairs in blue to the right side, those are jurors who will be sitting there. Sometimes these cases can be tried just to the judge, what's called a bench trial, but the law provides that you can have a jury trial in the Court of Common Pleas regarding these workers' compensation issues. I don't know if any of you have served as a juror. Normally I ask for a little show of hands for that, and we chat a little bit about your experiences, which we cannot do virtually, but if you have been one before, you might be familiar. But I mean, you can clearly see this is a completely different forum with a different set of rules. So as I said, the revised code, the statute in Ohio says you can appeal issues other than extent of disability to this court, and that usually means allowance issues, or it does mean allowance issues. The procedure here in court is completely different. This will take place over a series of several months. It is an investment. It's one that you, of course, are hoping will pay off financially or in terms of fostering a settlement. We'll talk about that in a second. But you begin by filing a notice of appeal. The injured worker is always the plaintiff and will file a complaint. The employer will file a legal pleading called an answer. You will go through a discovery process, which includes the ability to take the claimant's deposition. I talked about that earlier, which of course I love those because it's essentially sit down and ask every single solitary question you could ever think of in a friendly, conversational way. You can also exchange paper discovery, get documents, and then eventually it can be set for a jury trial. If you go through your jury trial, you of course would get a verdict, which you were hoping would be favorable in terms of overturning the allowance. So why in the world would you want to go through this protracted process that's going to take several months? You're going to have to pay a lawyer. It's going to be very expensive. There are a lot of reasons. That power to conduct the additional discovery that I talked about, to have that conversation with the injured worker, potentially get additional information to support your case. To posture difficult cases for settlement is absolutely a primary reason to pursue this type of litigation and can often be very, very successful. If you don't have any leverage and you don't keep your appeal alive, how well are you going to negotiate any type of a settlement? You have to have, some leverage in terms of appealing those allowance decisions. And of course, my favorite, you want to win. You want to take this to trial if that's what you decide to do. You, of course, want to have a favorable verdict, overturn the allowance. If you're a state-funded employer, You would be credited for what has been paid. If you're a self-insured employer and you're still part of the Cisco reimbursement fund, you would get back what you have paid. So just want you to know you can keep your appeal alive. Also, just in terms of the appeal process, any other issue other than allowance, like the payment of permanent total, the award of a VSSR, can also be appealed. Not to the Court of Common Pleas, not to that jury trial forum, not to that courtroom I just showed you, but to the Court of Appeals, which is more of a paper process called mandamus, where you're filing a complaint, an answer, you're exchanging the record, and the most important thing here is you're arguing these types of issues by way of a written brief. So both parties would submit their written briefs, often there is oral argument, and then a decision is made. And I guess you can also file objections to that. My appeal process is never ending here. You can even take it to the Supreme Court of Ohio, and that's actually what we did in this VSSR case. Basically, we got this wacky decision from a staff hearing officer that we know well, for many, many years, where he basically said that the employer could have implemented a safety procedure that no one had ever heard of before and that we didn't even think was possible. So we essentially asserted an impossibility defense. It would take too long to give you the facts, but basically these two employees were under a very, very heavy object that was suspended above, and it fell on them. They were very seriously injured, but somehow the hearing officer said we could have put something underneath it to support it, or this maintenance feature that they were performing could have been done some other way. But we were just trying to show mechanically that's just not possible. We just couldn't do it. So luckily, the Supreme Court agreed with us that it was impossible. The employer is not required to do something that is impossible, and that VSSR was overturned. So my advice, don't give up. Even though it looks like you're going to lose the game or you have lost the game at one level, there are levels of appeal. You can appeal to the Court of Common Pleas, as we talked about. It's very rare, it doesn't happen much these days, but you can also file those appeals to the Court of Appeals. And I would just encourage you to be very thoughtful about your workers' compensation defense, to implement these strategies, and to, of course, you want to be fair to your employees, but you do also want to aggressively defend your claims. And if they should not be allowed or they're not work-related, hopefully you have some strategies here to assist you in defending them. Feel free to reach out to me, and I appreciate the opportunity to speak with you folks today. And look forward to seeing you in person so much coming in July. Thank you.